Is that 2011 or
Yes,
2012?
that's right.
Justice Kadju, I think.
This is
You said PDF 161, which is actually a judgment called
Lalita Gupta.
Leela Gupta.
Leela
Gupta versus
Gupta.
Lakshmi Narayan,
Leela Gupta, my lords, at paragraph 13.
para 13.
My
Yes,
Lord Justice Bhatt has it.
I'm just trying to-
160.
Is it
If the Lord
PDF
will come,
161?
PDF.
my Lord Justice Kohli, my Lord, has it.
59.
Put it to 161.
Got it? हाँ भैया
Yeah.
Mila आपको?
Just above para 14,
Yes.
6 lines. The word spouse has been understood to connote a husband or a wife, which term itself postulates a subsisting marriage. The word spouse in subsection 1 of 5 cannot be interpreted to mean a former spouse, because even after divorce, when a second marriage is contracted, if the former spouse is living, that would not prohibit the parties from contracting the marriage. So only emphasizing this word spouse, my lords.
All right.
Although
What
that
else?
is apparent, my lord, this is one judgment which my learned colleague could find out. My lords, on
All right.
this.
What else?
Now, my lords, on the issue of originalism also, this is not in the compilation, my lords. In 2017, 12 SCC, page 1, Jindal Stainless,
Yes.
para 184 and 202,
Would you repeat it, please? 2000.
2017,
Yes.
volume 12 SCC, page 1, Jindal Stainless, para 184 and 202,
On original interpretation.
on, my lord, the entitlement of the court, my lord, to look into, or rather necessity to look into the Constituent Assembly debates. There are large number of judgments, but this is 9 judges,
Okay.
so, my lord, I just picked this out.
Not necessary to read it.
Not
We'll just
necessary.
take it. Yes.
Because n number of judgments are there, not where your lordships have looked into this.
Oh, yes.
Of course, Lord, I don't mean to say, Lord, that
But
things
they're
are
binding
frozen.
on things, yes.
That's not the contention. The contention is what I wanted is, Lord, that what are those circumstances, what are those limits, Lord, on ignoring, Lord, so there has to be something really
All right.
fundamental, Lord, which has an
Right.
impact. on
Point
that.
is taken. Yes.
That's the
All right. What is the next point now?
Then coming back to the written note, Lords,
Final written submission.
yes, final written submission. इस time में आगे आ गया।
Yes. Finally.
At page 9, there were 3 cases, my lord, which Mr. Vishwanathan cited. Well, you will find these 3 cases I've dealt with, my lords, and DS Nakara, my lords, and Vishnu Das. They were both on, my lords, administrative orders.
Cut-off date.
So it had nothing to do with a legislative enactment or a constitutional provision. So reading in or reading up and down, my lords, all those principles were not involved. Cut-off date was struck down in Nakara's case. And Vishnu Das, there was it's a transport matter, was a scheme found discriminating was struck down. And in association of old settlers also, it was a
Straight.
case of striking down some portion so that old settlers could also be accommodated. In none of these cases, not anything was read into any enactment. That too of a substantial nature, as is sought here. On Ghedan, my lords, much has been said. By the learned Solicitor General, all of which I adopt, my lords. If your lordship turns to page 14, kindly just note, Lord, that in Ghedan, my lord, I have extracted here. The Secretary of Council for the Secretary of State had conceded. And in the light of, Lord, amendments which are already before the House for permitting same-sex partnerships. And para 128, Lord Roger has recorded that. He records, certainly Counsel for Secretary of State who made submissions in favor of interpreting para 2 in this way did not foresee any such problems in reading like that.
Where are you
Also
reading that, Mr.?
Page 11, I think, page 10.
Clause D at the bottom of page 14.
Yes.
Third line, he records, certainly Counsel for Secretary of State who made submissions in favor of interpreting para 2 in this way did not foresee any such problems. It is also notable that by the time this judgment was delivered on 21/604, the bill relating to civil unions was already under consideration and ultimately received royal assent in December 2004. So these were the circumstances in which, and that too was a minor change which was done. But what is more important, you shall find in F. In MacDonald observed as below, if the court implies words that are consistent with the scheme of legislation but necessary to make it compatible with convention right, it is simply performing the duty which Parliament has imposed on it and on others. So it was a parliamentary act which required the court to make it compatible and tell the House. It is actually, this is an advisory jurisdiction because as the Lordship saw in section 3, which I have quoted at page 12 and 13, kindly at page 13, subsection 6.
Yes.
A declaration under this section does not affect the validity, continuing operation, or enforcement of the provision in respect of which it is given, and is not binding on the parties to the proceedings in which it is made. So this is a very
Next point, Mr. Gadvedi.
which separation of powers then will
All right.
not. In fact, after the court has given the judgment and it talks of that's the Constitution of India, Article 50.
Separation of the executive judicial.
What do you want us to look at, Mr.?
Article 50 in the Constitution of India, separation of powers. Hello, Justice Call has,
Yes, please.
50-50.
50.
Separation of judiciary.
Oh, yes.
The state shall take steps to separate the judiciary from the executive in the public services of the state. It doesn't talk about parliament, my lord. Now, there is significance, my lord, because I have quoted a number of articles where, my lord, parliament has in the judicial domain power to make laws, my lords. At page 21, your lordship will find in bold.
You know, actually, Article 50 was enacted in a different context because actually, even after the Constitution, until recently, there was no strict separation between the executive and the judicial functions, especially in the district judiciary. The idea was to ensure that the district magistrates, for instance, don't exercise the powers of a civil court. Even today, until
There are some
recently in the
places which are-
Northeast, for instance,
Even today.
even
by
today,
fruits of-
Commissioners and all that.
If you could have a, if you
But
could have a
I have not drawn the Lordship's attention to say that this is something decisive about the range of or the manner.
broadly the drift.
Because separation of powers is to be deciphered by referring to all provisions of the
best exposition
scheme of the
is in
constitution.
Indira Gandhi. Is in
Yes.
Indira Gandhi.
Yes.
What is separation of powers in India?
So,
All right,
entirety of the constitution has to be read.
So Dwivedi, this is very well settled. I think
Yes,
we can
yes.
move on to the next
Yes.
point.
No. What is it? Kindly, my lords, just note, my lords, three cases at page 24 and 25, where writ petitions demanding a common civil code, your lordship said it is for legislation. Then Hindu Adoption and Maintenance Act, your lordship says areas and aspects or facets of Hindu law which require modernization, modification, alternate are matters of legislative policy. That is 24 bottom, and then at page 25.
Of your note.
Yeah.
Then we read.
Udesh, Maharishi.
Page 24 bottom,
Got it, got it.
and running to page 25. There are three judgments where in the field of reforms, social reforms, your lordship said that it is for the legislature. The last one, my lord, is an order, my lords, in writ petition number 319, which wanted the court to intervene with regard to dowry menace and so on. The lordship said legislature.
All right.
Then next page, I'm not reading, my lordship, some foreign judgments are mentioned in the same direction.
Same-sex marriage. 29 numbers.
If your lordship comes to page 29, this is in the same sex context. For us. Oh, okay. This Obergefell, my lord, of course, is there, but we have quoted there also at page 26, 27. Just take the same view, and if your lordship recollect, they only issued a declaration leaving it to the.
11 states are body legislative.
Oh, that's, then page 29 is shoot Attorney General of Michigan versus Coalition to Defend.
Right.
We are the same, my lords. And 32 is Israel, where a foreign marriage, my lord, was the issue to be, it was not being registered in Israel. Para 33 is Panama, my lords, and it also mentions Thailand. These judgments are there in my compilation, lords. I'm not reading, it's all in the same direction. Interestingly, Panama is very close to America, my lord, yet discordant note. Now, kindly come, lords, then I come to Article 14. Because the first question is, is there a fundamental right, my lords, for persons in same-sex relations to marry, my lords, either flowing from Article 14, 15, or 21?
Mr. Dvedi, apropos a discussion which we were conducting between the three of us and my learned sister, does anyone have a fundamental right to marry?
But since certain judgments...
Forget the issue of same sex.
Yes.
Does anyone have a fundamental right to marry? Or is there no fundamental right to marry at all, according to you? Because your submission is that no one has a fundamental right to marry. Or is it, what is your answer to this?
My submission is simply this, my lord, that so far as heterosexual...
No, we are not on heterosexual.
That's right. Keep
We,
aside
are,
this.
we see that's what actually
of marriage.
triggered this idea.
Yeah.
Yes.
Does any citizen of this country for whom this court and our society and our polity has placed the individual at that highest pinnacle, and we have gone ahead and carved out, or rather discovered, so many rights: the right to personhood, the right of choice, the right of being left alone, the right of
Autonomy.
privacy, autonomy, which is at the core of personhood,
And dignity above all.
dignity, which is part of our preambular promise.
Yes.
Now, with all this, what is the question? The core question is, does a citizen or a person have a right to marry? Is it part of 21 or it is not part of 21? Granted that, but that in that sense, there is no unqualified right. We have to start with the premise that there is no unqualified right. The right to free speech is not unqualified. The right to association is not unqualified. Personal liberties are not unqualified.
Right to life itself is not
Right to life
qualified.
is not
Can be
unqualified.
taken away on
Therefore, we
convictions.
don't start with there is no unqualified right. There is no absolute right. If we start with that premise, what is the right? Does the right to life have that concomitant of the right to marry? So do not start the debate with whether same-sex people have the right to marry. Rather, what is the right to marry? Is there a right to marry?
So my submission is that the heterosexual couples have a right to marry in accordance with their custom, personal law, and religion. And that has been continuing. That's the foundation of their right. Now that right has been...
So, but therefore you concede the fact that therefore there is a right to marry under the Constitution.
Sure.
But that right to marry is confined only to heterosexual persons, according to you. Or is it your argument that there is no right to marry at all as a fundamental right?
I'm saying there is a right to marry which is founded on customs, personal law, and religion. The
And in
enactments
that case,
passed...
as you taking the same argument further,
Yes.
custom, culture, religion. Rewind 50 years ago, intercaste marriages were not permitted. Even go back further, Sapinda marriages were not permitted, right?
So
Interfaith marriages were unheard of,
Yes.
right? So all this, the content of the marriage has changed. Therefore, what was that fundamental right to marriage in 1954?
So these
Or
changes...
core content.
What is the core
These
content of the
changes,
definition
therefore,
of
have
marriage?
been brought about by legislation, and legislature can certainly, my lord, alter the customs. And now, my lord, the ghost of
The
Darasu has been...
Very keeping aside for a moment the legislative aspect, as you said, it's the culture, it's
Yes.
the customs that has brought about this whole matrimonial setup. Keeping that legislation aside, would you say that you're referring to the relevant articles of the Constitution? Is it that it is based and founded in the Constitution, the right to marry? Is the question.
So the Constitution only gives a fundamental right to form relations, associations, which is there in 19(1)(c), which can be regulated.
Persons.
Now, what we call our association as marriage has ultimately, over the course of years, resulted in a social institution. It's not an overnight something happening, my lord, and two people coming together and say, call it marriage. So it's a long period of time where this institution of marriage has emerged, and as a result of society's evolution.
So even prior to the Constitution,
Yes,
there was this whole customs, ceremonies,
absolutely.
and all of it.
Yes.
Once the Constitution came in, is it your argument that the marriage was...
So that right to marriage, which was existing as a part of social institution, will be accommodated in the right to associate in a particular manner and in a particular social institution. asking to open the doors of this social institution of marriage as existing for them. And that's the plea, that we stand at par for various reasons and therefore make the amendments in the SMA. SMA has now become unconstitutional, violative of Article 14. It may not have been violative of Article 14 in 1954-56 when a cluster of laws were codified.
By the same token, Mr. Dwivedi, Constitution has not granted anything. Go by the theory of the dissent in the habeas corpus, or even by what is generally accepted. It only recognizes and guarantees. Nothing is granted. We are free citizens. We have taken this onto ourselves. So the right to speak, the right to associate, everything is part of our inherent rights.
That's right.
The Constitution,
Yes.
therefore, does not grant. So even the legislations have only recognized. So that right to marry is inherent. If we say the right to marry is inherent, it is part of the Constitution. You may locate it in 19, you may locate it in 21, perhaps appropriately 21. Because 19(1)(c), the history you see brought was in terms of association, as we understand.
So it doesn't matter where it is located, or taking together it is located somewhere along with the preamble.
As we normally define a natural right.
That's right.
But the right to marriage in the sense in which
This is the problem. The moment we qualify it in the sense, because
that's important.
when you bring in the tradition, now the Constitution itself is a tradition breaker. The Constitution is a tradition breaker because for the first time you brought in 14. If so, let me just come. If you brought in 14, if you brought in 19, 15, and most importantly 17, those traditions are broken.
It can be broken.
No. Therefore, just allow me to continue with that thread for half a minute. If those traditions are broken, what is held hallowed in our society in terms of caste, we made a conscious break and said that we don't want it. We have even gone to the extent of encapsulating let's say an outlawing untouchability in the Constitution. I don't think there is any constitution in the world which says this shall be an offense as a part of its fundamental right. Therefore, traditions are there to the extent they are there. To the extent they have created the tradition, the institution of marriage, they are there. But at the same time, let us also be alive to the fact that the concept of marriage has evolved, which you yourself said.
No difficulty, Millers. Everything, a lot of evolutions have taken place. Other side has also adverted to them. We have also adverted. The point is, all these reforms which have happened are reforms, Lord, which are made by the legislatures in the interest of women and children. And they do not alter, my Lord, the fundamental aspect, the core aspect of the social institution of marriage as it exists, namely that it is an institution, it's a marriage, rather, my Lord, Hindu marriage, they regard it as a sanskar. So, as a sacrament, the fact that now divorce has come in, or my Lord, the fact that some other modifications have.
Yes, you're right. That is by and large, but
even
Hindu,
each and every reform, my Lord, kindly see 1937.
We are looking at what we understand as the traditional, but large parts of society. It's a very diverse Hindu society. That diverse society even today, and that's why you have Section 29 of the Hindu Marriage Act. You have customary divorce, which is preserved. Therefore, divorce existed in many communities.
Yes.
The diversity is there. That diversity we cannot.
Correct. So, therefore, what I submit is that the core aspect, what is the core aspect of that marriage? You may provide for maintenance, you may have alimonies, you may have divorce on certain grounds, you may provide that there will be inter-caste marriages, but ultimately the marriages remained heterosexual marriages. And number two,
Mr. Dwivedi, there are certain, to state at the extreme that there is no fundamental right to marry under the Constitution would be far-fetched. What are the core incidents of marriage. If you look at the core incidents of marriage or the core elements of marriage, not the incidents, I made a mistake. What are the core, what is the core content of marriage? Or what are the constituent elements of marriage? Just one second. If you look at each of these constituent elements, each of them is protected by constitutional values. I'm not saying 21 necessarily, but constitutional values. The preambular values read with 14 and 21. One, marriage itself postulates the right to cohabit, right? Of two individuals to cohabit together. Two, marriage accompanies with it the notion of a family, the existence of a family unit, because the two people who come together in a marriage constitute family. Again, something which directly owes its existence or recognition to the constitutional values. Three, to bolster your submission, we must take that into account also. Marriage has procreation as a very important ingredient of marriage. Though equally we must be cognizant of the fact that the validity or the legality or the social acceptability of marriage is not conditional only on procreation, for the reason that people may not want to have children. People may not be in a position, have the ability to have children, or they may get married at an age when they cannot have children. But we therefore take your point that procreation is a significant facet of marriage. There's no denying the fact, subject to these caveats. Four, marriage in a significant way is exclusionary of all others. Two people who come together in a marriage or want to cohabit together are entitled to exclude everybody else from that area of marriage. No third member of society can say that, well, I want to share in the same relationship which you have with one of you in the marriage. It's exclusionary of others. And five, which is equally important, just I gave you that thing about procreation, which is social acceptance of the existence of marriage. And social acceptance is then not just confined to that individual, but to the how society itself looks at that institution. Now, having said that, there cannot be any denial of the fact that the state has a legitimate interest in regulating marriage. Undoubtedly. Therefore, the state that's how the state regulates the forms in which you can enter into marriage. The state regulates how many people you can enter into a marriage when you have a subsisting marriage. The laws against bigamy, for instance. The state has a variety of other interests so that it regulates various facets of marriage. But we must therefore accept as a basic proposition that marriage itself is something which is entitled to constitutional protection, and it is not just a matter of statutory recognition. Once we cross that threshold, then we enter into the next level, which is the contested issue here. Is heterosexuality an intrinsic or core constituent element of the institution of marriage? Your submission is that as marriage has evolved, and even today, whether heterosexuality has social acceptance or not, is one thing which regulates the state's interest, because the state has a legitimate interest in regulating in marriage, and therefore it may say that I'll not recognize anything beyond a heterosexual relationship for the purposes of marriage. That's your contention.
No, so may I respond?
I just want to add something. Actually, the Chief Justice has, I had written something and the Chief Justice has virtually echoed the same thing, but I put it slightly differently.
Yes, ma'am.
I'll just read it out. What is the content? After all, what is a marriage to each other? One is to society. What a marriage to each other, each spouse, they decide what that marriage means to them. So what is the content of a marriage is defined voluntarily by the parties. That is the spouses. They decide, number one, whether to have and raise children, the procreation part. It is entirely their choice. Of course, there are social pressures. We are all aware of it. But ultimately, at the core of it, whether I will have child or both of us will have children or not is our autonomous decision. There may be marriages where parties may not live together. There is no cohabitation in that sense. Both are working. They may be meeting each other once or twice or 5 times or 6 times as they choose. So the concept of cohabitation. There may be no matrimonial home in the traditional sense. Marriages may not have any element or varying degrees of physical or sexual relationship. Now, therefore, as to what is the content, context, or cultural central to a marriage depends ultimately upon the participating, spouses. Is that right?
No, no, no. With great respect, no.
So you mean to say that if people... No.
This
Please. I'm looking at the voluntary part. I'm not looking at the...
Yes, I appreciate it. I appreciate what falls from my Lord. But that's the great debate which has been going on ever since the time of Kant and Hegel, my lords. Kant said, this is pure contract.
And keep the heterosexual element outside. We are not on that at all right now.
No, that's very fundamental. We can't leave it aside.
No. We are not saying that that is not relevant. We are saying we are testing the core proposition in regard to the content of a marriage.
Because one view is globally prevailing that some say that marriage is simply a contract. It's up to the parties to define, my lord, what marriage is. Marriage becomes a fluid concept completely, my lords. And that's one concept. And that, my lord, what are the consequences of this, my lord? I'll show to your lordship, my lord, by when I read the Nussbaum's article, my lord. She goes up to saying that then you will even have to knock down the prohibited degrees. She says that the state will have to provide justification in the court, my lord, why these prohibited degrees, my lord, cannot be. The health aspect, etc., has been knocked down scientifically. So therefore, knock down prohibited degrees. She even goes to the extent of saying there are 2 pages I'll like to read. Then they can, why not brother and sister can marry?
But that is not, that doesn't pose a constitutional problem to us because that's not...
No,
No, just a second. There you recognize the legitimate interest to the state to regulate. Now, what we are trying
where do we stop? Legitimate, because state has to come and justify why we are banning the prohibiting marriage between brothers and sisters.
Of course.
Mr. Dwivedi, it's not as absurd as that, with due respect, because I think in all societies, like barring a few, these prohibited degrees of relationship exist in some manner or the other. Age restrictions exist.
So again, we go back to the history, etc., and then see, Lord, that in Muslims it's a different...
Something even more fundamental. There's something more fundamental. Apart from blood relationship, there is marriage relationship. For instance, sisters-in-law, brothers-in-law. Why is that relationship? Why is that prohibited? There is perhaps a very deep-rooted, public interest in that.
Of course there is.
That is of some kind of order.
Yes.
Orderliness. So all these are legitimate statements.
But therefore the state has a legitimate interest to find out, Lord, what is that order, Lord, which is to prevail in the society, given society.
Mr. Dwivedi, that is not being questioned.
So I'm saying that if you treat this marriage as a fluid concept, which individuals in the 2 spouses are to define for themselves what it is, we don't need any law, etc. Then each couple will be deciding, Lord, what marriage has meaning for them.
I didn't mean that no law. I said there is a law. There is a law. I'm talking even of heterosexual. Nobody is compelled to have children. Nobody is compelled to live together.
Lords, that's the greatest of difference, I say. It is one thing that some couples, heterosexual couples, may decide not to produce. Some couples may marry and may want to, but they are unable to produce because of infertility, of medical reasons, biological reasons.
Go outside the precincts of this building and some of these complexes. You see construction workers, you see migrants who are away from their houses most part of the year. They go back barely for 15, 20 days. What is that family life? What is cohabitation for them?
Well, so we are on the aspect of marriage. Family life will vary from case to case,
exactly.
But marriage will not. With great respect, my lord, marriage cannot be made so fluid, my lords, so undefined. Marriage has the core purpose, as I was submitting, my lord, when your lordship put this query to me, is to bring about a unity of man and woman, my lord, for a social purpose. Because society needs to perpetuate itself. The race needs to perpetuate itself. Some may not produce, some may be infertile. These don't decide. The generality is that our population has grown from 44 crores, my lord, to 1.4 billion today, my lord, it's not because of certain people, some who did not decide to produce or were unable. We have reached here because, in generality, people want to come together, they want to cohabit, they want to, my lord, engage in sex, not merely for pleasure, not merely, my lord, for taking care of each other, but for building a family of their own, something out of their own body and flesh. It's all right, some people can adopt. These are exceptions. But the real thing is that we all want our own child and we try for it. We want it. That's how the family is built up. That's how the family, the child who comes into being, we build the relation, my lord, with the relatives. So our concept is different. Take any religion.
Mr. Dwivedi, if you therefore formulate and articulate the core content of a marriage, how would you do that?
Core content is the coming together of a man and a woman as commanded, as even Bible says, when Adam and Eve were there, that they blessed them for happiness and say, go be fruitful and multiply.
So therefore,
Every religion says procreation.
the definition is that procreation is the definition of marriage.
This society cannot survive. And so look at the problem faced by China and Japan, and today it is being said, my lord, by statistically that world is facing the problem of aging. We can't have IVF, my lord, and adoption. So in fact, adoption, what is adoption, my lord? Some heterosexual union has produced some children, my lord, maybe an orphan, and you adopt. What is IVF, my lord, and surrogacy? My lord, it's coming together of an egg and a sperm, my lord, together to produce a zygote. So ultimately, your family, your efforts to wanting to build something is dependent upon a heterosexual union. That's the fundamental truth. That's the most essential law of nature. That's the cosmic unity. And the society, my lord, cannot survive. Nations cannot be. What is national integrity, my lord, if this society grows old and there are no children? So producing children, bearing and rearing children. Bearing and rearing children. We don't want to go to the America way. Maybe there are, again, point out some families here, my lord, who are impressed by that, and where children leave the families at a young age and they are on their own. So everything is not beautiful there, my lord. And I have a very strong criticism of Justice Kennedy's judgment, Justice Sachs' judgment, and Nussbaum, Professor Nussbaum's. They treat marriage as a pure and simple contract, my lord. It's not a pure and simple contract. It's the most sacred phenomena, my lord, on earth. And not confined to human beings, my lord, but to other species, plants, and so on.
When you talk of right to marriage, which is what you were referring to, so marriage in any case transcends the constitution. It is not looking for its sanctity within the framework of a constitution, having predated it by several decades, years, centuries. So when you...
And as your lordship said, my lord, that the constitution enables the legislature to regulate. Over the course of years, we find development of society, my lord, we find certain things which were good at one point of time are no more good. We today want equality within the family. So that's one more change. Bigamy again is a protection. These are all laws which are protected under Article 15.3. 15.1 doesn't affect it. 15.3 commands the state to make special provisions for women and children. Bigamy is to protect women. Maintenance is to protect them. Alimony is to protect them. So therefore, all these laws which are being made, our rights are not, the heterosexual marriages don't depend upon this. No constitution can take it away. That I will put it like that. It's a natural right.
That's right.
By virtue of our being human beings. To deny that right means to let the nation die. That's the importance of this. And that's what Chief Justice Roberts in his dissenting judgments emphasized. And Justice Sachs in his judgment in 4 says, my lord, that this is not the essential characteristic of marriage. That's how the underpinning, two underpinnings. It's a pure, simple contract dependent upon two individuals, and secondly, my lord, it's not essential characteristic. I am therefore addressing your lordships not to follow the path of Obergefell and 4 millets. The path, they make a declaration. One was, my lord, to insert it. We have already made a submission, my lord, that SMA, my lord, you can't, it's not possible to insert by altering. And the other is not to, my lord, the other course of action would be, my lord, that, all right, make a declaration that they are entitled to marriage at par with heterosexuals, and therefore, and leave it to the parliament. That was one plea by Mr. Vishwanathan. So I am dissuading your lordships, my lords, from making any declaration in that context. Because those two judgments, of one is majority, one is unanimous, both are fallacious. Their underpinnings are completely wrong. In India, we don't treat marriage, my lord, as a simple, pure, merely because there is a consent. Even, my lord, I have annexed in the recent compilation, Faizi's, my lord, Muslim law. He was an ambassador to Egypt from 48 to 52, and then vice chancellor of the Jawaharlal of the Jammu and Kashmir University. And he has written, my lord, that it's not, even there this concept that it is pure contract is incorrect. You need a Qazi, my lord, presence. You need to recite verses of Quran, and therefore, so it's a mix. Something like seniority come merit and merit come seniority. My lord, in Hindus, it is sacrament plus contract because some consent is obviously implied. If that is to be treated as contract. And that is where, my lord, Hegel comes in, and Hegel says, criticizes very sharply and says it is shameful for Kant to say that it is a pure contract. And he applies the principles of contract and says that contract involves parting and exchange of externalities. When marriage happens, Lord, there is no exchange of externalities, no promise and acceptance in the sense of Indian Contract Act. So yes, consent is there. Both couples agree. If that is said to be a contractual element, yes. But it's not a contract in that sense. And the two judgments treat it as a contract. These are essential things. Why we don't treat it as a contract? Why the religions, all religions, even though they are in conflict with each other on so many things, yet all of them regard, Lord, the homosexual relation as a sin. Your lordships have declared it to be not a crime. But what about that, Lords?
But the moment you say that it is not just a matter of mere contract, but there's an element of a sacrament, which is again a fundamental precept of our law, at least insofar as Hindu marriages are concerned.
That fundamental precept of custom and
undoubtedly
religion.
That a marriage is not. I mean, that's the first thing which you learn when you learn the sense of Hindu law.
Yes.
But marriage is not merely a matter of contract; it's a matter of a sacrament.
Sacrament.
Once you accept the fact that it's not a matter of a pure contract, but it's a matter of a sacrament, then it's a sacrament which is also impressed with a constitutional character.
So I have no issues. Your lordship may find it located somewhere, but it doesn't depend on that. Your lordship may find its continuance there. What was existing up till 1950, by the coming of the Constitution, is not transformed into something which is by virtue of the Constitution.
That can be said of anything else.
Yes.
Everything else.
Absolutely.
You see,
It's not that we didn't exist as a society and the Constitution switched us on. No.
And that's the basis on which we overruled ADM Jabalpur when we dealt with ADM Jabalpur in Puttaswamy. We said that the fundamental fallacy of ADM Jabalpur was that if Article 21 is suspended during the period of an emergency, that does not suspend your right to life. Because your right to life does not owe its existence to the Constitution. It's a recognition by the Constitution. Therefore, the power to suspend 21 will not suspend your right to life. That was the whole basis.
I have no problem because
Right. Now, therefore, once you say that, well, marriage is a sacrament, then you have to accept that marriage as a sacrament traces its origin to 25, therefore.
because my submission doesn't turn on this acceptance. Your Lordship may locate it. I have no issues.
Right.
Your Lordship may treat it as part of life itself. I mean, if that is so fundamental, the right to life and personal liberty, so right to life itself will be marriage.
There is a fundamental right to marry within the meaning of the Constitution.
So right to life itself is
We are
marriage.
only joining issue with you that there is no fundamental right to marry.
No, I
You
never.
began by saying that there is no fundamental.
No, my
really
thrust,
constitutionally
I'm sorry,
involved.
because my thrust is been that there is no equality. Don't make a declaration that the marriage which is to be
So
declared.
in other words, in terms of constitutional, let's say, accept, there is a right to marry. In the sense that it is can be confined to heterosexual. But there is no marriage outside of that. There is no right to marry outside. So there
In
is
that sense,
and then
they may,
everything else.
it is up to the parliament. If the parliament
That's-
wants to create artificial definitions and declare it,
So
fine.
for instance, there was no prohibition of bigamy
Yes.
to marriage. So it was brought
Came
in.
in 56 for the first time.
For that marriage matter, there was no concept of divorce. As you say, sacrament, it is still sacrament, and yet there is divorce. Correct? It is still a sacrament among Catholics even now. And yet, if they want any one of them, they go into that and get divorced. So, Parliament has that, overriding whatever
That's right.
authority.
They
to the
can
extent
define marriage, redefine marriage, or create a separate law.
Exactly.
Define their relationship, my lord, in some different manner as many other countries
There's
have
no
done.
quarrel about that.
That's true.
It's ultimately in that. If it has to be, ultimately Parliament may have to do.
Out of 195 countries, only 44 countries have recognized the same sex. Maybe less.
And Mr.
34.
Dwivedi, then it leads us to one other issue, which is that assuming that you are right for a moment, that it is open to the state in the exercise of its legitimate interest, either to recognize a broader notion of marriage which goes beyond heterosexuality, or to confine it to heterosexuality. The state has a legitimate interest in saying that we will define marriage in such a way as would promote vital societal interests, including social acceptability or the stability of the social order. Equally, even if you were to concede that, there may be an alternative formulation. And that alternative formulation would be that apart from the element of heterosexuality, there may be other elements of that associational relationship which to a certain extent must find protection within our law, even if it were to be short of marriage, even if you were to accept your point. Ultimately,
what recognition, my lord, if your lordships are contemplating some sort of recognition from the state to that relationship is essential in order to protect, my lord, for protection to their relationship of love and affection, etc., family or adoptions or some other civil benefits. It's ultimately up to the parliament to decide what sort of recognition is to be given, to what extent parity needs to be given. I have at page 58, if your lordship will turn to I have set out at least 10 aspects of recognition which will have to be born in, and only parliament can do it. Just look at page 58 if I'll just
Mr.
go back.
Dwivedi, again, what you are saying is not something which is lacking absolutely in substance.
I mean,
there is a germ of substance in what you say. But equally, there may be, it's a more nuanced or a layered argument. One is sort of a constitutional recognition of the components of an associational relationship short of marriage. Two, the administrative or civic incidents of that relationship. And three, legislative recognition. Legislative recognition, legislative regulation, legislative acceptance undoubtedly has to emanate from Parliament. No question about it. 2, the administrative or civic consequences of a relationship, which the Solicitor General said that we are, obviously the government has taken the first step forward by saying that the government is going to constitute a committee chaired by the Cabinet Secretary. Second, but even more fundamentally, in some ways, and not so fundamental because ultimately it has to see progress on the ground, which is how do you define, how do you give meaning to the content of constitutional values? So even assuming that we accept your submission on the legitimacy of marriage as a social institution, the stability of the order, the legitimate interest of the state in protecting the concept of marriage as a heterosexual relationship, or deciding to what extent you will also dilute that concept, it's a matter for the state's legitimate interest and parliament to regulate. Equally, there is, even in this area that we are debating, some element of constitutional jurisprudence left for the court to evolve.
Look, with great respects, the court will not be issuing a declaration which is amorphous, vague. Some sort of recognition needs to be given. I mean, a declaration emanating from the lordships has to be concrete and definite, which results in something positive straight away in their favor.
Is it that something? Are we in a society, a constitutional society, and we are now approaching our 75th anniversary? Are we in a state where we say that a declaration by the state, by one of the co-equal wings, which is tasked with interpreting the constitution? I am not saying exclusively, because other wings also are entitled to. When it says that this is it, and beyond that it will not say, it cannot say, because it cannot implement it.
And we are conscious of the fact that we cannot tread into the legislative domain.
So once we say that, does it not have its own force? Are we trained? Let me just complete. Is common law seeped into our bones to this extent that everything that we say needs to be executed through contempt or through some execution proceeding? Is it not sufficient that the court says that this is the state of affairs, and that's out there for the people, for the parliament, and other branches of governance, including constitutional branches of governance? And I'm not talking of only the constitutionally recognized branches of governance, the society at large, that this is the state of affairs. How it is assimilated is not up to us.
I'm certainly not saying that lordship's jurisdictions to make an appropriate declaration is not there.
I'm taking it beyond the writ of mandamus. I'm just taking it.
What I'm requesting and beseeching your lordships is that please do not issue a amorphous, vague, too general a declaration which has no meaning.
But take the case of privacy, right? We located privacy in constitutional precepts, but we were conscious of the fact that if we have to implement privacy in the concept of, say, informational privacy or data privacy, we can't do it ourselves. It has to have a legislative backing, and therefore we left it to Parliament to legislate. But Mr. Dwivedi, the very act of the court having granted a certain degree of legitimacy, constitutional legitimacy to privacy, has a very vital role to play in society.
No, but that was not a general exercise because the lordships had an Aadhaar Act in front.
No. When it came to the 9 judges, there was no such.
It was independent.
It was argued. You are aware.
9 judges reference came from that only.
Correct, maybe, but then it was an abstract reference.
Because Mr. Rohatgi argued that there is no right to privacy.
The only question was privacy is there or not.
But then it's a wider concept now. There is no law.
Even 9 judges' judgment did not involve any declaration for the purposes of Parliament to do something.
All right, I'll go back. What did 11 judges do? 11 judges did not have a statute before them. Mr. Sibal is there.
No, they didn't.
There is no statute which has been invalidated. There was no statutory model.
No, it was a reference in a pending proceeding. With great respect, certain questions are every day referred.
So what is the content of 30? Mr. Dwivedi also argued. We all know that. It was only argued what is the content of 30. It's in the abstract.
No,
Why you're finding it difficult? What we are talking about, both Chief Justice and Justice Bud is talking about, if there is a right, it's a recognition of a right. The order of a court is in the context of recognizing the existence of a right. It's thereafter for the legislature. Court might not be able to do or take up any executive action to implementing it.
so
Once there is a recognition and court stops there, it is thereafter for the
so
executive
that's
to take
precisely
it up.
where I'm, my lord,
And it's
engaging
one of
in-
the most important and
No, I appreciate, my lord,
function
but
of a
this is
court to give a
precisely where
recognition.
I'm engaging in this debate, my lord, is that when it comes to recognition of a right, then this is a sphere. What sort of recognition your lordships will be providing?
Absolutely, you're right.
That's the
Now, let me just state 10
That's
points, my lord.
exactly what we are also deliberating on.
matter.
We are sort of introspecting at this stage. We are now almost towards this last third of the arguments. That's why we sort of,
In fact, that's one of
we are
the
also in a
core
state of
functions the court.
mental
No, I appreciate.
churning.
It's important, my lord, for such debates to happen, and therefore, my lords, I'm requesting your lordship just to listen to this, my lords. Now, if your lordship wants to, sorry, my lordship.
No, please.
Go ahead.
Please.
If your lordship is considering, hypothetically, I'm taking.
And Mr. Dwivedi, a lot of what we say to you is not only meant for you, it's also meant for the other side.
My lords, by now, my lords,
You are fully
at the
aware.
fag end of our careers, my lord, we are aware of all this, my lords.
You're conscious of that as much as we are. After long
Many a
experience at the bar.
times. That's how it is.
That's how it
Quite
is.
learning a lesson.
churning process.
Yeah, of
And
course,
I
my lords.
think in a way, we all of us here are privileged to
In
go through
fact,
this exercise of the mind.
One important aspect of this proceedings is, you know, that there is churning in the society. People are,
Right.
because of this debate, there is,
Absolutely.
and because of the live streaming, so in different corners of the country, people are thinking about it.
There
And
is
there
a-
are, you know,
Mr. Dwivedi, so many which ways actually. The live streaming of court proceedings has really taken that our court absolutely to
different
the homes and to the hearts of common citizens. And I think that's part of the process. I
the
mean,
only thing is that our debate happens in English language, and in the villages, etc., people will not be able to follow, my lord. And the language problem in India is very complex. So,
But you'll be surprised. We are working even on that, Mr. Dwivedi. Even
Yes.
that is not lost to the Supreme Court on its administrative side.
Live audio
We are working on this. You see that transcript which we
Yes.
have there?
it's being
We're
translated.
now trying to use technology to ensure that the live streaming content can be
Yes, immediately.
simultaneously made available in
That's
languages
great.
which the citizen can
In
follow.
fact, technology now allows,
Of course.
if you are speaking in English,
Subtitle.
Speech to text.
simultaneously be heard in Japanese
Yes, correct.
without a translation.
We have it.
It's speech to text.
Mr. Sibal.
Mr. Sibal,
Mr.
it's
Sibal,
speech
it
to
is
text.
right.
Telugu,
Yeah, or speech to speech as well.
already.
Not only it's available,
Yes.
it's very much available.
And that's the beauty of it.
That's the beauty.
We must put
Basically, Millards, we are in the midst of a tectonic shift in societal values. Where we recognize it, where we stop, is the issue before the court.
Absolutely.
That's the issue.
So there are 10 aspects, you know, which will arise.
Now, Mr. Dwivedi, as the
page 58.
as the head of the family, I have to now hurry you along. We are in the thick of debate with you, but we need to now just hurry along so we get everybody else
So
a chance.
just let me just
Yes. Now, just 10 points if you can formulate so that we can then take it down.
already
there.
Yes, you have put it down.
That's what you are saying, D9, right?
Yeah.
page
So let's
58,
quickly look at it and then
page
we'll wrap up.
58.
Page 58. No?
D9. D9.
Yes.
D9.
D9. So various aspects of recognition, my lord, and therefore I am submitting, my lord, that this has to be left to Parliament, my lord. It can be debated there only in the legislatures. So many aspects are required. And unless all of these enter into your lordship's consideration and some declaration comes, my lord, which measures all these.
Let's see D9.
the claim for recognition gives rise to several questions. That is, what sort of recognition needs to be given? What form of recognition should be given? Should the recognition be given by inclusion in an existing law or means of a separate law? Should the recognition be given at par with heterosexual marriages? To what extent parity needs to be given? Should parity be given at one go or in phases? What should be the spacing of phases? What will be the repercussion of granting par with either heterosexual marriages or transgenders? Determination of whether a majority of same-sex relations and transgenders desire particular recognition with all consequences. Whether the society is sufficiently ready to accept the particular kind of recognition to be given.
Thanks, Mr. Dwivedi. Can we now wrap up, Mr. Dwivedi?
Now,
I think you've made your point on this.
Now, on 21, Mr. Rohtegi said.
Where is your 21 argument, Mr. So we can just quickly run through that.
Detail.
So just a word about Article 14, where I was when this Lordship put questions to me. And that is, that.
Mr. Dwivedi, why don't you do this? You are right, we interrupted you. In 2 minutes, you can now wrap up your Article 14 arguments. We have the overall perspective so that you can just
I'll
put it together and
let each one of them, my lords.
Page 32, Chief.
On Article 4. Drawn attention to two aspects, in addition to what has already been submitted by the learned Solicitor General. The first is, that when this Act, Special Marriage Act was made in 1954 and the other codifications, at that time, there could be no discrimination at all because of existence of 377, which came to be struck down much later. So at that time, when the Parliament was confining itself to making certain regulatory measures, codifications with respect to heterosexual marriages alone, there could be no contention raised that at that juncture, my lord, it was. So the only question will be, my lord, what has happened subsequently is only Navtej which has decriminalized, which comes, my lord, now, 4 years back. And is the consequence of this change such that these laws or any of them become discriminatory and violative of Article 14 now? There are cases where Lordship said that a law may be good when made, but subsequently some supervening change may have happened, my lord, which may result in its becoming discriminatory. So it cannot be, my lord, this law immediately on a declaration in Navtej results in these legislations or some of them becoming discriminatory and therefore requiring, my lord, whether it should be altered or not. Because the question of alteration arises only if this has become discriminatory. The second aspect which I wish to submit is that in view of the core idea of marriage which I have submitted before your lordships, in view of the immense continuity, my lord, the enormous continuity of these customs, etc., even today, it cannot be said that this has become discriminatory because these laws have not been amended to accommodate them. So the question of knocking down this does not arise. Particularly keeping in mind, my lord, that Parliament is fully entitled not to make a comprehensive legislation. After decriminalization, there has to be a process. How long it will be or not, one doesn't know. It is for the Parliament to assess and decide when to come out with what law. It cannot be said that now this judgment, Navtej has come, so within 4 years have passed, nothing has been done, and so now make insertions, amendments. Now at page 42, my lord, is Article 15. My respectful submission is, my lord, that 15.1 doesn't have any impact because most of the regulatory laws and the substance of them is to provide protection to women and children. And it is protected, therefore, by Article 15(3). That's one. The second is, my lord, at page 43, in Indra Sahni's judgment, the majority view emphasizing the presence of the word only. I have extracted that portion at page 43. Your Lordship will have the last 4 lines. When in such circumstances, provision is made for reservations, for example, on the basis of caste. It is not a reservation in favor of the caste as caste, but in favor of a class or social group which has been discriminated against. And discrimination cannot be eliminated otherwise. What the Constitution forbids is discrimination within court only on the basis of caste, race, etc. However, when the caste also happens to be a social group which is backward or socially and educationally backward or a weaker section, the discriminatory treatment in its favor is not only on the basis of caste. So therefore the word...
That goes as far as it goes. In that
Yes.
context, it's 100% right. But there can be other shades to this only. Supposing you are while employing someone, you say you belong to, let's say, Uttarakhand, and therefore I'll not employ you. And say you also there are other factors.
All I'm saying is that the word only therefore has to be established. If it is only on the ground of region or religion
I'm putting
or
it
something...
the other way, Mr. Dwivedi. This only has to mean something else, in my opinion. Of course, I'm speaking against the grain because Nargesh Mirza and other previous judges. Only cannot mean that this proscribed ground can also be there, plus others. Can you say while employing? I'm not talking of reservation. That somebody is
So
an ST or an
it
ST.
cannot be any plus plus. Any insignificant plus plus. That
anything
my Lord
else
Justice Chandrachud has said.
that in Navtej.
In Navtej, Your Lordship
Also
has
the
said.
army, women's matter.
By way of
Yes.
emphasis.
So I'm not meaning that. Then any insignificant plus plus
So
something. and therefore-
discrimination otherwise on the ground of gender will be valid,
But
so long as it is a discrimination on gender and some other attributes.
bracket it
That's
with other
that's not how you
But
interpret Article 50.
but if the other attribute is a major one, which is also being factored, then yes, it will have a play. My Lord. That's what I'm submitting. That's what follows from...
Then
And
this
our
be-
theory has gone far beyond, Mr. Dwivedi. Now we have spoken about intersectional discrimination.
Even so, my Lord, we can't ignore the terminology which has been deployed there of only. My Lord. It can't be ignored, yes. As far as I'm concerned, I will say that any insignificant or minor plus will not be...
You have to give that content.
Correct.
But
The
here-
word only has to be given a content, which is
that's
more
all.
compatible with the
Otherwise-
Constitution as we see
But
it
here
today
the-
evolve.
But here, proceeding further, my Lord, the question is, we are taking note of one sexual orientation. Moving forward, my Lord, one sexual orientation which is resulting in the same-sex relationship. But there is the other sexual orientation which is involved in the heterosexual marriages, which I have already elaborated. My Lord, it's not that that is not a sexual orientation. That is also a sexual orientation, particularly when the women are being protected and is squarely following under 15(3). So that sexual orientation is of coming together for the purposes for a good of the society. The procreative good is a good of the society itself.
That point you have made, Mr.
So, but that's also a sexual orientation.
All right, thank you, Mr.
Now-
Dwivedi. I think we can now go on to Mr. Civil. I think we've given,
Just one, my Lord, if I may just submit a paper, my Lord, about why, my Lords. There's 2 pages which I have given to your Lordship.
today.
Yes.
Is it part of the
नहीं, ठीक है, दे दो. Just have your junior email it also so that it becomes a
I
part
think it
of
has
the-
been emailed.
No,
Your Justice,
just email it to the court master. So it'll become a part of our electronic file.
Other side goes.
So Dwivedi, this you have already stressed actually. You have spoken about why Kennedy and Sachs are wrong and why you don't accept Mata Nausbaum's writing. We'll have a look at it, Mr.
Your
Devi.
Lordship, may I have a look?
Yes.
I'm grateful, my lord.
Thank you very much, Mr. Devi. Yes, Mr. Sibal.
Won't take too long, my lords. Lordship has already, my lords, gone through all the law.
Does he have a written?
Well, I don't know. I've sent my propositions, my lords. They're already hopefully before your lordships.
Hey,
Under what head? What head?
We also have printed.
No, Mr. We don't have that.
don't have any of
If you can have some, your junior,
We've
email it
circulated.
to the court master, we'll immediately get it.
We've circulated it, my lords, but
No,
we'll give you the print.
Nothing. Not on the,
It's been,
just
then.
just send.
I've got physical copies
No,
also.
let's do it on the electronic form, all of us.
Give it to them.
Mr. Sibal, what happened to your iPad?
I have it. Well, lords, I have it, and I'm going to honor, my lords, my commitment to your lordship.
We had to do,
In this field, at least, my lords.
do it in other courts too, besides
No,
court
it's a
one.
temporary measure.
Is it a proverbial elephant's, task?
No, my lords. In fact, I have been assiduously, my lords, trying to learn on a daily basis, my lords, and I've managed, my lords, quite well. My lords, I'll start off by saying, my lords, that I was very worried, my lords, at the outset of the hearing, when on the other side it was said that Parliament is not going to do anything about it. We don't expect Parliament to recognize this particular right. And therefore, we urge your lordships to give us a declaration. Because I'm afraid that that's a very dangerous proposition.
Sorry, will you repeat yourself, Mr. Sibal?
I'm sorry?
Will you repeat yourself?
Well, it was said, Malaj, at the outset, that we don't expect Parliament to move forward. We don't expect Parliament to pass such a law. And therefore, your lordship should do it. And I said, Malaj, that's a very dangerous route to take. Any law of this nature, Malaj, which is pursuant to a tectonic shift, as I said, Malaj, in societal values, requires public discourse, which includes discourse in Parliament, it includes discourse outside Parliament, within the assemblies, outside society. And therefore, Malaj, a declaration by itself on the premise that Parliament is not likely to pass a law, Malaj, is, as I said, a wrong step forward. But Malaj, let me go to the heart of the matter. When your lordships were dealing with Nalsa, you got it?
What's happening in 14?
16. 18.
The dangerous route to take, Malaj, because a declaration by your lordships will close the debate in Parliament. There will be no scope of debate once you declare. One, that it's a fundamental right. Two, it has to be recognized. That's, Malaj, with the greatest respect, Malaj, something that your lordship should be cautious about. Nothing more than that.
Parliament can overrule a declaration also, no?
Sorry?
Parliament can overrule a declaration.
No, no, but your lordship knows that once your lordships have declared, Parliament cannot overrule it. I hope, Malad, that stage has not come for Parliament to overrule what your lordships decide. I'll be on the other side when that happens, Malad. But Malad, let's Malad go to the heart of the matter. In Nalsa, your lordships decided sexual identity. Sorry. In Nalsa, Malad, your lordships decided,
Nalsa, you say.
yes, sexual identity, nothing more than that, of transgenders. In the privacy judgment, your lordships decided upon the contours of privacy, both in the private space and the public space.
Can you say that again? Nalsa was a declaration.
Yes,
Identity.
there was a declaration.
Identity.
Yes, exactly. On sexual identity. In privacy, you decided on the space for privacy, both the private space and the public space. That even the public privacy must be protected. In Navtej, you decided on decriminalization.
So conceptually, you say the third one is slightly different
Yes,
because it is only a decriminalization, which is statutory.
correct. What you are today deciding are two things: sexual unions and recognition by the state of sexual unions. That's the issue, Malaj. None of these issues, Malaj, were looked upon, decided, contemplated, thought through in either of the three judgments. So any Malaj reference is made in the context of those three particular issues decided in those three can't Malaj be taken as concepts which must be a fortiori accepted by your lordships. Right? So first you have to decide, are they a separate sexual identity? And in the ultimate analysis, Malaj, my answer will be yes. The next step, should they be recognized by the state? The answer is not through a declaration. This broadly, Malaj, is going to be my submission before your lordships. And Malaj, I respectfully, Malaj.
Just a little clarification. Your first question was, are they a separate sexual identity? And you said yes.
Yes.
Second, should they be recognized by the state? And your answer was not through a declaration.
No, their sexual identity, yes.
Yes.
right? Once your lordship recognizes it, then the question arises, sexual identity as a sexual union.
No, I just had a little clarification because, I'm just
Yes.
taking the submission down. Second point was, should they be recognized by the state?
Yes.
To which you said not through a declaration.
Not through a declaration.
Now, when you say should
Not
they,
through a legislation, I said.
not through
A legislation. No,
No,
they can only be done through a legislation.
yes, that's right. I took it down.
So you're basically you're advocating a Scalia-Roberts approach.
Yes.
Right. Now,
Absolutely.
when you said, Mr. Sibal, when you said should they be recognized, that's what my question.
That sexual identity,
Sexual
which is
union.
separate from sexual union.
Sexual union.
Union.
Not sexual identity.
No, identity, Malad, I want your lordship to give that declaration.
So that word they, we'll just modulate it to
Yes.
the sexual union.
Union, yes. Now, the question then arises, is this sexual union a marriage? That's what we've been debating, Malad, for the last an hour or so.
It was the third?
Is this sexual union akin to a marriage? If it is akin to a marriage, is it founded in any provision of the Constitution? Next question. And then the third, for it to result in certain rights, it can only be done through recognition by the state, through legislation. There can't be a declaration to that effect. Well, it's when your lordships ask the question.
Constitutional perspective, the constitutional lexicon.
Yes.
When you say can't,
Yes.
the can't has to also fit into some constitutionally recognized prohibition.
Yes. Which
You
is,
would say
Malad, that it's a regulatory exercise of rights ultimately have to be regulated.
No,
Regulation can only be done through law.
No, that's right.
Yes.
That's part of regulation. We are on a more fundamental path.
Yes.
Declaration.
Yes.
We have now evolved to the extent of understanding what are constitutionally manageable standards,
Yes.
existence of it, non-existence of it, matters which are not to be gone into the court by the court, etc. Where would you locate that? When you say a prohibition is prohibited.
Malad, moment your lordships decide that this union is a marriage, in what context will you decide that, Malad? Ultimately, what is a marriage? The marriage is only a union.
Forget the issue of whether the court should declare this to be a marriage.
Yes.
We are now on the core issue as whether the court can issue a declaration.
That it's a marriage.
No,
that is a union.
That the court can issue a declaration.
A declaration, what, Malad? That it's a sexual union. That's all, Malad. It can't be doing anything more than that.
Right. See, there is no declaration in vacuum.
No, Malad, there can be, Malad.
Of course, you're right. But see that the court has in its repertoire a right to declare right from 1960, Justice Subbarao, I think that Kochuni onwards, which is there. Question is, what is that declaration we have to issue? Will it be marriage or not marriage or something?
No, that is the question that, Malad, I'll try and address your lordships on, but that's the really core issue.
So the court has in the past issued declarations, for instance, declarations which postulate that the implementation of the declaration requires legislation being enacted by Parliament.
Yes.
The right to a clean environment, for instance.
Yes.
The implementation is ultimately for Parliament to say health, education, which eventually the right to primary education found expression the Right to Education Act.
Yes, absolutely.
Or the
became
right
a
to
constitutional
food.
right thanks to a certain declaration.
Or the right to food, which eventually resulted in the enactment of a legislation.
I'm with you on that.
Therefore, at its core, constitutional precept to say that the court cannot issue a declaration would not be correct. Equally, we take your point that don't go into an area where you declare a right to marry. Because that's Mr. Divedi.
That was the intent. That was the intent. Malad, let's first of all define what marriage is before we move forward. And Malad, my Lord Justice, but your lordships, Malad, let's look into that. Ultimately, what is marriage? Forget about the law of 1955 Act. Forget all that. Marriage ultimately is a union. It's a union of two persons. It's a sociological phenomenon which deals thus far with heterosexuality. Thus far. It's a union, Mulats. Even if the 1955 Act were not there, Mulats, it's recognized within and without as marriage. When I say within, by two people, pay that union, and without by society. So there are two elements to it. Recognition within, recognition without.
Could you just elaborate on that a little bit?
Well, let's, for example, I mean, as I said, in the absence of a law, this union of two people with all the sacramental vows is accepted by a large majority of society for thousands of years.
That's the recognition without.
Yes, that's the recognition without, right? And that's essential. That's essential.
So the recognition without, according to you, then is the social recognition.
Is the social recognition. Thus far, it applied to only heterosexual couples. But it's still a marriage. But a marriage which is gained acceptability over centuries. The union between sexual union between sexually people who are homosexuals or whatever is still a union. You can't say it's not a union. They have a sexual identity which is separate. It's involuntary.
Involuntary?
In the sense, well, it's involuntary in the sense that these are their sexual.
It's not a matter of choice.
Yes.
That's what they call as ascriptive.
Yes.
Yeah. See, in that
they have no
sense,
choice in the matter. That's how it is physically.
It could be said of both in that sense.
Sorry?
It could be said of both sets.
Yes, of course. Of course.
But that apart, it is voluntary in the sense that they choose.
Of course. I don't mean.
Just like in this.
The manifestation is involuntary. Otherwise, it's of course a voluntary union. I don't mean that, Melissa. It's consensual. It's voluntary.
Your sexual orientation may not necessarily lead you to a union.
That's right. It may not. It may not. That's what I'm saying, Melissa. Therefore, we are not talking about sexual orientation here, which is what I was started with. We're talking about a sexual union. And we are trying to give that a name. That's what we're trying to do, Melissa. That's why you'll also ask the question, what's a marriage?
Right.
Right? You give it a name. Now, they may consider that this is my marriage. Who can stop anybody? How can anybody stop them from considering that this is a marriage? Nobody can stop them. There are two people who decide that they want to live together. They live together for 10 years, 15 years. They say, I'm married to him. The moment you say now without, you must recognize it, comes the problem. You may find it in 21, you may find it in 14, you may find it anywhere else. You may not find it in the Constitution at all. According to me, it's part of your right to be and to live as you please without interference from the outside world. It's part of privacy.
And according to the recognition without, if the court were to be invited to give a declaration of recognition without,
yes,
that would amount to an imposition on others.
That's the point. That's the point. That's the core issue before your lordship. That's really the core issue.
If I could just translate it in a very colorfully, maybe not so. It's like drawing a blank.
Yes.
It's like firing a blank. So which means that you allow it, but outside, without, there is no acceptance, there is no.
That's really the heart of the problem.
The counterpoint to that is there may or may not be, but that lends us dignity in our own eyes. That lends us acceptance among our society.
Yes.
And the society without, to that extent, limited extent, among our parents, among those people who are willing to accept us. That is a point you may have to
True, Malaj. That's certainly an issue that your lordships will have to consider. But the point that I'm making is, Malaj, at the moment, what are they asking? They say under the Special Marriage Act, the rights given to heterosexual couples should be given to us. That's what they're asking. That's their ask, Malaj. Nothing short of that. And that's what your lordships is considering.
Mr. Sibal, when we opened the discourse, we confined it, of course, we confined them to the Special Marriage Act with the idea in which we still maintain that we are excluding the whole gamut of personal law from the debate.
Yes.
But we're not really confined only to the contours of the Special Marriage Act in deciding the broader constitution.
That I know. 14, I'm going to come to that, Malaj. That's the other issue. Is it discrimination?
So when we locate the nature of marriage, the institution of the marriage, we're not really then confined only to the Special
I agree,
Marriage Act,
Malaj. Therefore,
contours.
I agree entirely. Therefore, your lordships are also considering whether there's discrimination under 14 or not. And therefore, can you then say that this is discriminatory? But where does it go from there? That's the next question. If you find it discriminatory, where do you go from there? That's an even more difficult task, Malaj. First, to find that it's discriminatory, that itself is an issue, Malaj. Because we are talking about separate sexual identities and unions.
We'll continue.
Yeah, we'll continue.
Mr. Sibal, roughly how long will you take just to have a...
I won't take much time, Malaj. I'm not going to trouble your lordship with all the judgments. I'm just taking the dialogue forward, Malaj, so that your lordship knows.
Because now we've seen the judgments. We'd like some assistance at the intellectual level now, and we just forget the judgments unless there's somebody else.
That's correct. That's what I'll do.
After Mr. Sibal, who will be taking over? Mr. Datar will be, and after Mr. Datar, Mr. CJI, Deepak. So Aishwarya will be arguing. All right. Then
just about half an hour, not
so we've Mr. Datar, Ms. Bhatti, Ms. Manisha Lavkumar, and then Mr. Jayasai. So we would tentatively, this is not the sort of a bench which wields a guillotine, but tentatively we'll keep it for lunch tomorrow for this side.
I think so.
So that then the other side will conclude their rejoinder by tomorrow afternoon.
That's fine. Deeply obliged.